It's at short notice. On Fridays, some decisions come out, and we cannot wait for the weekend to comment on them because they are such great decisions. I am Mary Rose Wilcox. I'm a community activist, former Maricopa County Board of Supervisor for 21 years. And I am here today with many, many people I'll introduce in a minute because the findings of fact from Judge Murray Snow came out, and we want to comment on them. These findings are very tough, and we will all comment on them in a moment. Let me introduce the table. We are very, very honored to have Dan Kubota with the ACLU here today. As you all know, ACLU, along with Malda, took the reins in this trial and did a magnificent job for us. Dan will explain, we'll start out, one of the attorneys explaining the order. And then we have Tony Bustamante, who is here. Antonio has been our civil rights attorney for many of our groups and has tracked this case from its inception. And Daniel Ortega, a civil rights attorney, and Danny has gone very, very far back, along with all of us, in saying this is not right, and today proves it was not right. We have to my right Salvador Reza, who has led the community groups in protest against the actions of Sheriff Joe Arpaio. He represents Doña Tierra, but he also represents a large cadre of community neighborhoods who have suffered because of Joe Arpaio. Lidia Guzman, who is one of the original plaintiffs in this case, did Respecto, a hotline that called a lot of the people who had been having trouble called in, and a lot of their cases were used in the Melendez case. And we have Martin Quesada, our state senator. Martin is a lawyer and has been an advocate on immigration issues for a very, very long time. And we have Margarita Blanco with Somos America, and Somos America has been on the front line along with all of us. We also have Tony Navarrete, who's here representing Promise, Arizona, and Tony has been, since he's a very young man, fighting this battle with all of us. We are here today. I'm going to turn over to Dan in a minute because he is the lawyer. But I was very struck when I got the decision, and it's a long decision. It's 167 pages, 162 pages. But right off the bat, what struck me is this paragraph. In short, the court finds that the defendants have engaged in multiple acts of misconduct, dishonesty, and bad faith with respect to the plaintiff class and the protection of its rights. They have demonstrated a persistent disregard of this court, as well as an intention to violate and manipulate the laws and policies regarding their conduct as they pertain to their obligations to be fair, equitable, and impartial with respect to the interests of the plaintiff class. And the plaintiff class, as we all know, are people who live in our neighborhoods, our communities. Many of us represent many of the plaintiffs. Many of us have families and friends. And Joe Arpaio and his underlings, Chief Sheridan, Chief Sands, and Sosa, violated their rights, and today justice has been served. Let me turn it over to Dan Kubota. Dan, let's sit here so you get the mics. All the speakers will sit in this chair.
Thank you, Mary Rose, and all the others here. I have been with the ACLU of Arizona with this case since 2008. But the folks who've been up here have lived with the reason for this case for many years before that, and their commitment and courage on the streets was what made the case possible to begin with. Today's decision is a culmination of the past years, specifically the order to show cause signed by the judge about a year ago that found that there were grounds for looking into potential contempt actions by these defendants led by the sheriff. The bulk of the decision today basically covers very important, detailed, and comprehensive findings of fact. It does also mention an order which really contemplates some future proceedings. Just real quickly, following this, the parties have to present to the court any written submissions they have in response to these findings of fact, and that's due May 27th, and maybe I'll finish reading it by then, but that's when the findings are due. And then on May 31st, there's an open hearing in court about these findings of fact and the next steps, and specifically what remedies, what has to be done in order to ensure, not an easy task in this context with this particular defendant, as we know, to ensure compliance in the future. What remedies, and that's what remedies are for once there's a finding of civil contempt. The judge, as he has done throughout the case, did a very comprehensive and thorough job and detailed all of his conclusions, even intermediate sub-conclusions, very specific references to the record in this case. There were many, many hours of hearings over the past year on the potential contempt, and the judge did a terrific job. These will not be able to be challenged by any reasonable persons. We know that some will challenge them anyway, nor by an appeals court. This is an appeal-proof, comprehensive decision where the judge very much details his findings based on the record, on the testimony, almost all of which was testimony from MCSO personnel and the sheriff on down. And the bottom line is the court found that there was contemptuous behaviors on the part of the Sheriff Arpaio on all three grounds that this case was brought on, the order to show cause, that one of the other defendants, the head chief, the person who runs the MCSO day-to-day, Jerry Sheridan, on two of the grounds, and the other two people, former Chief Sands, who's not been with the department the last couple of years, and Lieutenant Sousa on one of the grounds. All four were found that they had violated intentionally and knowingly, in the words of the judge. Very important finding. This was not just an accident, negligence, gee, we could have done more, which was the tack that they took during the hearings. People may know that at some point some criminal attorneys were brought in because of the potential referral for a criminal contempt charge, and apparently those attorneys decided they were going to try to get rid of these hearings in this court, knowing the abilities and comprehensive work of Judge Snow, by throwing themselves on the mercy, if you will, of the court and saying, we did it. We, Joe Arpaio and Jerry Sheridan, were guilty of contempt, but we didn't mean to do it. It was an accident. It was negligence. We could have done more, didn't realize it wasn't happening, didn't realize for 2 years people were being picked up illegally throughout Maricopa County. Gee, had we only known, we would have done something about it. Because the major, in any event, the judge found just the opposite. And that this was intentionally and knowing violations, not only of his orders, but then there was a cover-up, and those, if they read it, and we can get some questions later, I don't want to take too much time now, questions later, or in days to come, when I really read it. And I only have my cell phone with me today. It was not time to read this in great depth. He found that the cover-up was as bad as the initial actions or non-actions by the sheriff, and they intentionally took steps to try to demonstrate that there was not any wrongdoing. The judge called them sham proceedings in the internal administrative proceedings, and documented at great length the fact that they were just show trials. There was never any possibility of holding people accountable. That was not their intent. They manipulated who was going to run them within the MCSO. They changed the dates around so that the penalties would not be so great, and barely found one person, as I recall, guilty of a serious infraction, given all these, despite all of these clear violations. The main one, let me just mention briefly, and again, we can save time for questions, is of course the violation of the court's preliminary injunction, which was issued in December of 2011 in this case. It's a preliminary injunction, which of course was required not only by the facts of this case, but by the United States Constitution, which says you can't just pick up people from the street without probable cause or reasonable suspicion. And the court just said, you can't do that. That's what the Constitution requires, the Fourth Amendment's prohibition on unreasonable seizures. And stated that the fact that you, the MCSO, you, the sheriffs, have suspicion of people's status, and we know that's what he had done over the years, when he was trying to stop any brown-skinned person that he could and round them up and sort them out afterwards because of his focused, obsessive focus of FCSO on immigration-related matters and his boasting about that to the country many times. In any event, the judge in his preliminary injunction basically stated what, of course, the Constitution requires. You can't pick people up without reasonable suspicion or probable cause. They were doing this regularly. They kept doing it from 2011 for about the next 2 years, knowing that the court had ordered them to change and in fact harming many people in the process, people who were picked up who otherwise wouldn't, people who were deported, people who were harmed by that. That was the primary finding in terms of contempt. There were other very serious findings of contempt based on failures by the defendants to turn over matters prior to the trial in this case in 2012. They were required, as any other defendants are, to provide information requested by the plaintiffs that's necessary and available, necessary for trial, and they found that the court found that they ignored that requirement as well. And there were many occasions, the third prong of the order to show cause was failures to provide materials that were known had to be turned over to plaintiffs, including, people may recall that incident with some 1,400 plus IDs that were found in various traffic stops were obviously relevant to this, and the spectacle of the various FCSO officials and their attorney stating, oh, gee, we didn't realize we had to turn those over. So those were the three areas of contempt. And as I said, in addition, the judge found that their attempts to cover up their intentional disregard of the court orders further added to demonstrating their attitudes of contempt for the court and for court orders. And we have a history in this country of serious violations, whether you're standing in front of a schoolhouse in Birmingham, Alabama to defy a federal court, or you're here in Arizona to defy a federal court. It's a very serious matter, and perhaps we won't need federal troops in this instance. That's not up to me to decide what remedies will be available, but it demonstrates a continuation of the attitude and actions and disregard of the community held by these defendants. As we know, at trial, the court found that there had been for years systemic violations of the rights of the Latino community, violations of the 14th Amendment Equal Protection Clause and the 4th Amendment. And now we have a continuation even after that finding, and the judge's very comprehensive 142-page decision after the trial demonstrating that, and in a finding that was upheld by the Ninth Circuit Court of Appeals. So now we're at this situation where the disregard and total contempt for the rule of law, for the federal courts, and of course most importantly for the rights of the plaintiff class and people of the community has been fully demonstrated for the world to see.